So first of all, the general rule, which has existed for over 100 years, and this is a judicial statement that the law respects the existence of the corporate entity if duly established. And the graphics in this coming slide, the one after this next slide, will be a bit distorted. I apologize. So first of all, I'll just give you a summary of the facts. This case is useful to read because the language is a bit antiquated. The also presentation of the facts in the law are a bit indirect, and so therefore it's a good challenge to improve your reading skills. But let me, in any case, just help you a bit with some guidance. So what we have is Aaron Solomon, who has a business which is essentially a sole proprietorship. It could be potentially a partnership with his oldest children. And then he enters into this person who is essentially irrelevant for our purposes, but he's mentioned in the facts. So I'll explain what he does. And it has to do with the older incorporation procedures in the UK at the end of the last century, the previous century, the 19th century, where Adolf Anhalt acts as a trustee in order to receive assets and incorporate the company, which will be set up as Aaron Solomon and Company Limited. This is similar to the promoter function that we already discussed, but there's no collection of assets. What's similar about it is we have a third party interacting between the members and the company in formation. So then a memorandum of association, similar to what we now have as the Articles of Association, was executed by Aaron, his wife, a daughter, 4 sons, each of them subscribing for 1 share. And the reason why this was done, the UK law at that time required an initial 7 shareholders. Hong Kong now allows a company to be set up with a single member. As I said, the company's name is Aaron Solomon and Company. And then we have nominal capital of £40,000 divided into £1 shares. At the outset, we have a loan, which is given by Mr. Broderick. And this is relatively significant because Mr. Broderick then ends up suing the company, not receiving full payment, and he's the person who is initiating the action that then later goes on to consider protection of other creditors. And then later, after the company is established, Mr. Solomon receives 20,000 shares. So the company's share register shows 2,001 shares held by Aaron, and then 6 shares held by his family members. So what we have then is a boot business, and hopefully the graphics will work here clearly enough so I can demonstrate this to you. So we have a boot business, and you see this is something like a sole proprietorship. We have some assets, we have a workshop, and we have Aaron Solomon. Then the company is created, and assets are transferred to the company in exchange for a shareholding plus a set of debentures. I'm simplifying here by not showing Aaron Solomon's family members. So we have essentially a holding by Aaron Solomon of the 20,001 with a couple of shares in the hands of his family members. Mr. Broderick comes in and loans money to Mr. Solomon. He becomes a secured creditor on the strength of debentures he holds. But what Mr. Solomon does is have the company provide the security to Mr. Broderick, and you can see the letters of the IOU from the company to Mr. Solomon. I've decreased them. You couldn't see them decreased because the graphics aren't working. But the extent of the debt that the company owes to Mr. Solomon has been reduced in exchange for providing the security to Mr. Broderick. As the company goes forward, we have unsecured creditors providing things like leather and wood and nails and transport for the boots. And these people have running credits against the company. Now, the company starts doing poorly. And what is agreed is a transfer to the secured creditor. And then remember, Mr. Solomon, although being the majority shareholder, is also a creditor of the company. And so then we have a transfer to Mr. Solomon as well, which leaves no funds for the unsecured creditors. And then the question is, was this a scheme to defraud creditors, because Mr. Solomon was both the largest majority shareholder and also a creditor of the company? He controls the company, and yet he receives the treatment in winding up superior to the other creditors of the company. At the first two levels of decision, we do have a requirement that Mr. Aaron Solomon indemnify the company for its debts to the other creditors. And then the case goes to the House of Lords. The House of Lords finds that the company was set up properly, according to law, without fraud, and therefore Mr. Solomon will be a member of the company. The debts of the company are not Mr. Solomon's debts, and therefore Mr. Solomon enjoys his payments from the company in connection to his standing as a creditor. Now, the reasons for Solomon are essentially really one, and then two supporting policy arguments. So the primary argument, you could combine the first and the third bullet points in the sense that the company was created according to statute without fraud. Okay? So the court looks to the statute, finds what the UK Companies Act requires. And by the way, the UK's Companies Act that's being applied is 1862. And that was the first foundation of the original companies ordinance brought into Hong Kong in 1865. And the court reads the statute and sees that Mr. Broderick followed the requirements of the statute. If you remember what we discussed in our second lecture, the requirements for incorporation today are much lighter than the requirements that Mr. Solomon had to follow when incorporating his company. And then there was no lack of fraud. And the fraud was primarily the possibility that Mr. Solomon would contribute assets to the company which were overvalued. So if he were to value his assets, let's say at $10,000, and the actual value of the assets was $1,000, that would be an understandable reason why the company could go into liquidation. But the court found that there was no good evidence that Mr. Solomon had transferred assets fraudulently inflated in value to the company in exchange for his shareholding. And then finally, we have a public policy, which is essentially that the company limited by shares is the foundation for the entire economy. As I said, in Hong Kong, we have well over 1 million companies, more than one company for every 7 people. And all of the business, nearly all of the business, is done through companies limited by shares. And if the structure of the company were to be taken away, the foundations of the buildings of the economy would rattle and shake. And this is also true at the time of the decision, with the British Empire being one of the largest multinational structures that has ever existed in history, spanning to every continent and using companies limited by shares to do so. So there is a strong policy argument for respecting this. There are also policy arguments, however, for taking extraordinary measures to protect the victims of companies. Now, in Erlinger, we have victims which were victims because the assets were transferred to the company in exchange for shares at incorporation with an inflated value, and then the directors who assessed the value of the assets were deemed to be puppets of the author of the fraud. And so Erlinger is a good example, even today, of when the corporate veil could be pierced, because here the company is established with fraud. And where we look at the piercing of the corporate veil, we will always be discussing capital. Because if the company had sufficient share capital and sufficient assets generally to compensate creditors, whether they be tort or contract, then the entire issue of piercing the corporate veil would not arise. So lacking assets will always be at the core of these cases.